فأصلحوا بينهما فإن بغت إحداهما على الأخرى فقاتلوا التي تبغي حتى تفيء إلى أمر الله فإن فاءت فأصلحوا بينهما بالعدل وأقسطوا إن الله يحب المقسطين صدق الله العظيم যদি মুমিনদের দুই দল যুদ্ধে লিপ্ত হয়ে পড়ে তবে তোমরা তাদের মধ্যে মীমাংসা করে দিবে অতঃপর যদি তাদের একদল অপর দলের উপর চড়াও হয় তবে তোমরা আক্রমণকারী দলের বিরুদ্ধে যুদ্ধ করবে যে পর্যন্ত না তারা আল্লাহ তাআলার নির্দেশের দিকে ফিরে আসে যদি ফিরে আসে তবে তোমরা তাদের মধ্যে ন্যায় পন্থায় মীমাংসা করে দিবে এবং ইনসাফ করবে নিশ্চয়ই আল্লাহ তাআলা ইনসাফকারীদেরকে পছন্দ করেন আল কুরআন সূরা হুজরাত আসসালামু আলাইকুম ওয়া রাহমাতুল্লাহি ওয়া বারাকাতুহু
Thank you, Maulana Mahmoud Kamrul Islam. Now, I would like to introduce the Chief Executive Officer of BIAC, Mr. Kaisar A. Chaudhary. Mr. Kaisar A. Chaudhary joined Bangladesh International Arbitration Centre BIAC on 1st February 2022 as its Chief Executive Officer. Mr. Chaudhary holds a master's degree in economics from the University of Dhaka and is a professional banker, having started his career with Greenwich Bank in 1975. He held several senior positions in the banking industry, including the positions of Deputy Managing Director and Managing Director of the country's 3 commercial banks, and also officiated as the Principal of Training Institute of Dhaka Bank Limited. Currently, he is in the Board of Premier Bank Limited as its Independent Director. I now request Mr. Chaudhary to deliver his welcome address.
Thank you, Mahbubur Rahman, for the introductory note. Sadly, I have to start with a bit of a distressing news that our special guest today, Justice Sarkar, is not available with us. Under bereavement, loss of his father-in-law, early last night, and also the Deputy Speaker of the Parliament. In honor of the departed soul, may I humbly request you that we all stand in silence for 1 minute. Thank you. Respected Session Chairman, Mr. Mahbubur Rahman, Chairman of Bangladesh International Arbitration Centre, BIAC, respected Chief Guest, Honorable Minister of Law, Justice and Parliamentary Affairs, Mr. Anisul Huq, MD, Honorable Vice Chairman, BIAC Board, Mohammed Rumi Ali, keynote speaker and distinguished panel of discussants at today's seminar, members of the BIAC Board, dedicated colleagues at BIAC, distinguished presence in the audience of the representatives from the government offices, law practitioners, corporates, finance industry, BIAC members, print and electronic media. Assalamu alaikum and a very good afternoon to you all. It is a proud moment for BIAC as it celebrates the 11th year of its founding. I stand here to welcome you all to this seminar event. Personally, it is also a proud moment for me too, as I feel honored to be given this opportunity to address your excellencies and personalities of eminence. You have opted to make adjustments to your schedule and spend time with us and share with us a moment of joy. And further, be a witness as well as a contributor to the proceedings of the seminar. On behalf of BIAC, please allow me to express our humble appreciation and deepest gratitude for your gracious presence. BIAC, the not-for-profit institution and solitary institution for ADR in Bangladesh, was set up through the generous sponsorship of International Chamber of Commerce, Bangladesh, and the country's two principal business chambers, namely Metropolitan Chamber of Commerce and Industry and Dhaka Chamber of Commerce and Industry. Over the years, BIAC engaged itself in the process of enrolling its own members, signing partnership understandings with practitioners and stakeholders, building relationships with regional ADR centers, arranging or facilitating training sessions, awareness programs, seminars, webinars, etc., in order to materialize its mission to promote arbitration and mediation as a cost-effective and speedy ADR mechanisms in the country. BIAC also has been the center for numerous arbitration and mediation proceedings, both on ad hoc basis, under the coverage of the Arbitration Act 2001, or under the umbrella of the set of rules for arbitration framed by BIAC in conformity with the said Act. BIAC also has had the privilege of presenting to the Bangladesh Bank a few years back a draft of the guidelines on ADR for the benefit of the banks plagued with cases pending in the money loan courts. To embed the ADR culture, BIAC took the initiative to hold sessions with the authorities of the University Grants Commission, private universities, and Bar Council with a plea to introduce ADR courses in the curriculum of higher seats of learning. And to make things interesting, BIAC organized inter-university arbitration contests at national and international levels. We intend to continue with this initiative in the years waiting. All of these were possible due mainly to the recognition by and continued support and patronage of national and international concerns, as well as the cooperation received from the best and most respected legal minds of the country. We are indebted to them for their support, and we will continue to rely on their patronage to carry on with our movement to popularize ADR mechanisms in Bangladesh. Taking into account the introduction of the Arbitration Act in 2001, followed by emergence of BIAC 10 years later, and the Earth's revolution for the 11th time since then, one would have naturally expected that the Med-Arb route would be the natural first choice of the disputing parties. Sadly, it is not so perceived. The disputing parties continue to have a preference to crowd the courts, leading to unnecessary consumption of time and money. The dream to do business in a friendly environment continues to remain a dream. This gives us the incentive to search for the reason or reasons for which the ADR system is being compelled to take a back seat. In the process of a search, we set the tone for today's seminar and selected the theme, the Arbitration Act 2001, dire need for immediate reform. We are thankful to Barrister Rishad Imam for voluntarily taking a keen interest in preparing and presenting a keynote address on the subject. We are thankful to the distinguished panel of discussants with Barrister Ajmalul Hussain QC joining us online from London, who shall be taking the pains of analysis and collectively identify the causes impeding progress of ADR system in Bangladesh and suggest workable remedies. We pray in earnest that the seminar recommendations receive deserving attention of the regulators and the policymakers, and that we devote our enthusiasm to remove all bottlenecks or impediments to make ADR a supportive and an effective better half of our judicial system. BIAC is pledged bound to lend its helping hand at all times to progress the initiatives. And finally, I ought to thank my team at BIAC who has worked ceaselessly over the past few weeks for the celebration arrangements. Thank you, dear team. Further, a load of thank you notes to our dear advertisers who have once again stepped forward to take the concern of solvency off our shoulders and help us particularly publish a special anniversary issue containing thought-provoking articles, a few of which are pertinent to the seminar theme. Lastly, let me repeat my words of welcome. Excellencies and distinguished guests, we are delighted to have you with us, and we do hope you enjoy the exchange that is soon to follow. Joy Bangla. Now it is time for me to pass on the microphone to Mr. Mahbubur Rahman to take charge of the proceedings of the session as its moderator. Mr. Mahbubur Rahman is more than the chairman of BIAC's board. He is a dreamer of BIAC, and being so, he is passionate about anything and everything that involves the ADR system, and always keen to invoke the role of BIAC to make it a success story. An eminent businessman of the country, Mr. Mahbubur Rahman is also the president of International Chamber of Commerce Bangladesh. He is the only arbitrator from Bangladesh for the China International Economic and Trade Arbitration Commission. Mr. Rahman is the chairman of Eastland Insurance Company Limited, chairman and CEO of ETBL Holdings Limited, and chairman of the International Publications Limited, publishers of the Daily Financial Express, and also the chairman of National Housing Finance and Investments Limited. He is the only businessman from Bangladesh to be listed in the 150 high-impact leaders under the Creating Emerging Market Project 2020 at the Harvard Business School, USA. Over to you, sir, to act as the moderator of the session.
Thank you, Kaiser. It has been a pleasure to have the opportunity to welcome the distinguished people of the legal profession, as well as the justices from the High Court and Supreme Division. And I would like to take this opportunity to welcome the chair. I would like to take this opportunity to welcome our chief guest, Mr. Anisul Huq, and the Honorable Minister for Law, Justice and Parliamentary Affairs. Thank you very much for joining us. The arbitration and the legal proceeding at all cases and on all times is a dry subject. So to attract more people in our events, sometimes it will be difficult. And more particularly, in this case, those who are in the need of having such kind of amicable settlement or alternative dispute resolution, we need to invite them and ask them to be with us and to take this our initiative of the alternative dispute resolution institution to which we explore, because in Bangladesh we always prefer to go to the court instead of settling it outside the court, despite the fact that we have in our presence a lot of examples, and more particularly in the United Kingdom, this 90% of the cases, disputes are settled outside the court. So in this case, it is very important that we have to popularize the alternative dispute resolution in the country, and in which case I must admit and agree the government is very positive, proactive, and trying to bring in a lot of amendments in the laws to bring the alternative dispute resolution in its right place. But however, it seems that we yet to achieve our target, and it takes time, but I think we should not lose further time to bring it about it. As you have seen that our today's 11th University seminar that we have organized in order to find out that if the alternative dispute resolution has to take place, that Arbitration Act 2001 dire need for immediate reform, and without which I believe that we will not take hold of the situation. Thank you very much, Honorable Minister. He has been, from the day one he took over the office, he has been supporting our initiative, but unfortunately that it is not matching the desire and demand of time. But from his side, he is 100% supportive of this, and we need to work together to bring it to the situation where it is needed. So at this point of time, I would like to say thank you once again, Honorable Minister, for joining us. And as our Chief Executive has already mentioned, we had a special guest, Justice Justice Kushiyar. He lost his father-in-law, who was also our Deputy Speaker of the Parliament, and that is why he could not be late home. And therefore, nevertheless, we would now like to take our normal course in the proceedings of today's seminar, and I would like to urge each one of our distinguished speakers, as it is 12:52, and we would like to take everything on the dot, and I believe each of our speaker has been given the time for 5 minutes, but not enough, I consider. But we should have to bring about a situation in order to finish it on time. Our key representative, Mr. Rishad Imam, Barrister at Law and Advocate Supreme Court of Bangladesh. Rishad Imam is a partner of Akhtar Imam and Associates, one of the most reputed law firms in Bangladesh, and a practicing advocate of the Supreme Court of Bangladesh. He is an independent director of a leading financial institution in the country. He specializes in company and commercial litigation and arbitration and constitutional litigation in Bangladesh. His experience has been acquired over 12 years. He obtained the first-class LLB degree from the University of Birmingham and LLM Master of Laws degree from the University of Cambridge. He was called to the bar, English bar, from the Honorable Society of the in 2007. Mr. Rishad Imam, the floor is yours.
Grateful to the Honourable Chairman, Mr. Mahbubur Rahman, sir, for the introduction.
Good afternoon, Honourable Chief Guest, Minister of Law, Justice and Parliamentary Affairs, Mr. Anisul Huq, sir. Honourable Vice Chairman, Mr. Rumiali, Honourable CEO, Mr. Kaiser Choudhury, distinguished panelists, and ladies and gentlemen. The Honourable Special Guest, Mr. Justice Mohammed Khurshid Alam Shaukat, sir, could not be here with us today due to the sad demise of his father-in-law, the Honourable Deputy Speaker of Parliament, Mohammed Fazle Rabbi Mian. This is an irreparable loss to the nation. Now, today's discussion, ladies and gentlemen, is of vital importance if we are to reap the full benefits of arbitrations and if we are to popularize arbitrations in Bangladesh. Now, the entire objective of arbitration is to provide a cost-effective and expeditious form of resolution of disputes. Unfortunately and somewhat ironically, the Arbitration Act 2001 has had the opposite effect. Now, Bert Lance, a very close advisor to Jimmy Carter in 1977, said that if something isn't broken, don't try to fix it. Unfortunately, I would like to vehemently state that the Arbitration Act 2001 is broken and it needs urgent fixing. Now, due to time constraints, I will not be able to deal or touch upon all the relevant amendments that are required to this Act, but will only mention some of the most important ones. So without further ado, I would like to begin with the first one. As you can see on the slide, ladies and gentlemen, the Arbitration Act 2001 does not provide mandatory time limits in many important aspects, resulting in significant delays and expenses for the parties for resolving disputes. Section 23(2) of the Act states that an arbitral tribunal shall deal with a dispute as expeditiously as possible. In practice, it is observed that due to the lack of a mandatory time limit in the law, arbitration proceedings continue for a very, very long time before an award is delivered. Now, it is most of the time that is because the lawyers of the parties seek adjournments after adjournments on fictitious grounds and frivolous grounds, and even filing applications on baseless grounds, forcing the arbitral tribunal to dispose each and every application on its merits, thereby wasting time. So I propose, ladies and gentlemen, that for both domestic and international commercial arbitrations, we include a mandatory time limit of 12 months within which the arbitral tribunal shall be bound to complete the arbitration proceedings, which may be extended by a period of 6 months with the consent of the parties. Now, this, if the arbitral tribunal fails to complete the arbitration proceedings within the time limit, the mandate of the tribunal shall be terminated by operation of law. Now, this is not something new. India has incorporated similar provisions in their act with regard to domestic arbitrations. So Bangladesh should definitely follow suit. Like that change or The next point I want to make, ladies and gentlemen, is that when an arbitration award is challenged in court under Section 42, the Arbitration Act does not stipulate any kind of time limit within which the court shall be bound to dispose of the application. So in practice, we see that due to severe backlog of cases in courts, and also due to the lack of a mandatory time limit in the statute, there is monumental delay in disposing of such applications. Now, as an example, in a case involving my chambers, Akbar Imam and Associates, we won an arbitration award against a public body in 2009. And the public body challenged the arbitration award in the district court, and the matter is still pending in the district court. It has been over 12 years, and the matter is still pending in the district court. Now, I propose that we include a statutory time limit of 6 months or 1 year for the disposal by court of an application challenging an award. Once again, this is not something new. India has amended its Arbitration Act and included similar provisions. The next point I would like to make, ladies and gentlemen, is the fact that since awards are deemed to be a decree for the purpose of enforcement, there is no fast-track process provided for enforcement of awards. Now this potentially leads to the parties getting tied up in the court system for a very long time. Now this particular aspect of the current statute acts as a deterrent for parties when deciding whether or not to insert arbitration clauses in their contracts. Now, what can be done about it? I propose we insert a provision for fast-track enforcement of arbitration awards. For example, enforcement proceedings, instead of beginning from the district court, could start from the High Court division. The next point, ladies and gentlemen, is that the Act does not even contain any option whatsoever for the parties to choose a fast-track arbitration procedure. What is a fast-track arbitration procedure? It basically is a procedure where the dispute shall be resolved within a very short time on the basis purely on written pleadings without the need for any oral hearings. Now, the Act needs to be amended to insert such a provision where the parties may, before or at the time of appointment of the arbitral tribunal, choose to resolve the dispute using a fast-track procedure. Now, such an option has several advantages. For example, one, it is ideal for resolving minor disputes where the parties do not want to be involved in protracted proceedings. Two, it is ideal for complex disputes where time is of the essence for both parties. And three, it is significantly cheaper for the parties. Once again, this is not something new. India, through amendments, have incorporated similar provisions in their act. The next topic I want to discuss is that of interim remedies. Now, in view of Section 3 of the Arbitration Act, the court has been given the power to grant interim remedies in an arbitration, has not been given the power to grant interim remedies in an arbitration seated outside Bangladesh. And this has been recently confirmed by a larger bench of the High Court Division in a case. I've given the name of the case on the slide, if you could see. First appeal number 209 of 2016. This has been recently confirmed that the court does not have the power to grant interim remedies when it comes to arbitrations seated outside Bangladesh. Now, this is problematic, ladies and gentlemen. Why? Because in an arbitration seated outside Bangladesh, where the respondent's assets are located in Bangladesh, the claimant may win an award in the foreign country and may come back to Bangladesh to enforce that award, only to find out that the respondent has dissipated all the assets, thereby preventing enforcement. So the claimant will then be left with a paper award. So I propose that the court should be given the power to grant interim remedies under Section 7A of the Arbitration Act in relation to arbitrations seated outside Bangladesh. Once again, this is not something new. The UK Arbitration Act and the Indian Arbitration Act both provide similar provisions. The next point, under the general umbrella of interim remedies, the Act does not provide any guidance whatsoever when it comes to the different types of interim orders the arbitral tribunal can pass under Section 21. And any interim order passed by the arbitral tribunal is not even considered to be a decree of a court as per the Act. So the Act needs to be amended, ladies and gentlemen. The Act needs to elaborate and give proper guidance and effective guidance as to the different types of interim orders the arbitral tribunal is capable of passing under Section 21. And the Act needs to also provide that the arbitral tribunal under Section 21 shall have the same powers for passing orders as the court has in relation to any legal proceedings before it. Now, the Act also should provide that under Section 21, if an arbitral tribunal passes an order, it should be considered to be a decree of a court and be enforced on a fast-track basis. So the next point, ladies and gentlemen, is with regard to forum for challenge and forum for interim remedies. Now, according to Section 42 of the Act, in case of domestic arbitrations, a party can challenge an award by filing an application before the district judge, which may then be challenged before the High Court Division, and which may then be challenged again in the Appellate Division, and of course they have that option of review again. So as a result, the parties to a domestic arbitration are having to go through the entire process of civil litigation, which they had actually intended to avoid by inserting an arbitration clause in their contracts in the first place. So the statute clearly discriminates, I would stress on this word, discriminates between parties to domestic and international commercial arbitrations, since an award from an international commercial arbitration can be challenged directly before the High Court division, where unlike domestic arbitrations where the challenge has to be made to the district judge. Now the High Court division can also directly pass interim orders for international commercial arbitrations, unlike domestic arbitrations. So I strongly, ladies and gentlemen, propose that we need to remove the jurisdiction of the district court to hear challenges to a domestic arbitration award and pass interim orders and give exclusive, and I stress on this, but exclusive jurisdiction to the High Court division to hear all challenges to all types of arbitrations and to pass all types of interim orders in relation to both domestic and international commercial arbitrations. That the High Court division, to put it very mildly, is far better equipped to expeditiously deal with issues arising from arbitration proceedings. The Act provides, ladies and gentlemen, ample scope to a party to challenge an arbitration award on grounds capable of being interpreted too widely. For example, especially the grounds mentioned in 43B of the Act. For example, ex facie opposed to the laws of the country. Grounds like opposed to public policy of Bangladesh. Now, as an example, I can refer to a case from my chambers, Arthur Imam and Associates. It was a high-value ICC arbitration seated in Bangladesh. We won the award in 1989. The other side challenged the award, and the matter took over 3 decades, 30 years, 3 decades to be resolved. The main reason for the delay was the fact that the High Court division reviewed the entire merits of the dispute at that stage, which surely was not the intent of the legislature. Now, this effectively rendered the arbitration proceedings almost an exercise in futility. Now, I propose that amendments are required to further clarify, define, or even curtail the grounds on which an arbitration award may be challenged. The Act needs to elaborate what it means by public policy and ex facie opposed to the laws of the country. The Act needs to define what it means, explain what it means. The Act must expressly limit the power of the court by stating that the court cannot review the merits of the dispute at this stage. For example, India amended its laws, and one of the grounds for challenge was patent illegality on the face of the award. They explained it to me. They explained it in the body of the Act and said that it does not mean that an award may be set aside merely on the ground of an erroneous application of law or reappreciation of evidence. So Bangladesh urgently needs to follow suit. The next issue I want to deal with is foreign arbitral awards. The ease with which foreign arbitral awards and international commercial arbitration awards are capable of being enforced in a country has a direct effect on foreign investments. Foreign arbitral awards are enforced like a decree of a civil court. As such, there is no fast-track process provided in the Act for enforcement. The Act also provides ample scope to a party to prevent a foreign arbitral award from being enforced. And on the grounds of what? Public policy. Without the Act does not even define what that means, but they provide a ground that on this basis a foreign arbitral award can be prevented from being enforced. Now I propose we insert a fast-track process for enforcement of foreign arbitral awards. For example, enforcement proceedings once again should begin in the High Court division. Singapore and India have amended its arbitration laws to insert similar provisions. And once again, we have to define what we mean by public policy. We have to explain. The Act needs to explain what public policy means in this context. A party against whom a monetary arbitration award is granted may file an application to set aside the award without any form of security being deposited in court, since Section 43(2) of the Act does not make it mandatory for the court to require such a party to deposit the money payable in court. The Section 43(2) states that the court may ask for a deposit, but it does not make it mandatory. So this may provide undue advantage to a party, as he may be able to delay the enforcement of an award by merely filing an application for setting aside the award, all the while enjoying the money legally owed to the other party. So what needs to be done here is that the Act must provide that in order for a party to challenge a monetary award, the party must deposit the money payable by the award in court. Now, similar provisions are in the Orthorin Adalat Ain have proved to be very effective in preventing or even dissuading loan defaulters from filing frivolous appeals in court. The Arbitration Act in Section 38(7) does not even provide any guidance as to how the costs of arbitration shall be determined by the arbitral tribunal. Costs of arbitration include arbitrators' fees, legal expenses, administrative expenses, and expenses in relation to arbitration proceedings. In the absence of guiding principles, there is ample scope for disproportionate and unreasonable costs to be fixed. Furthermore, the section does not provide any guidance as to the factors to be taken into consideration for determining the liability of the parties regarding costs of arbitration. The Act should contain provisions which will ensure that the costs of arbitration, especially the fees of the arbitrators, are proportionate and reasonable in the facts and circumstances of the dispute. The Act should expressly provide some of the factors to be taken into account for determining the liability of the parties regarding costs of arbitration. For example, the arbitral tribunal should take into account whether a party had made a frivolous counterclaim which resulted in delay of the proceedings, whether any reasonable settlement offer was made by one party but unreasonably refused by the other party, whether any party was attempting to delay the proceedings using unethical tactics. So the arbitral tribunal needs to consider these factors when awarding costs. The last 2 points, ladies and gentlemen, I would like to quickly mention is that arbitration rules are important to flesh out the provisions of the Act. It has been 21 years since the coming into force of this Act. No rules have been framed till date. Under Section 57, the government has express power to frame rules, but it has not been done yet. So urgently, the government needs to consider framing rules. The Act also needs to lay down at the very outset the general principles that will guide the parties and the court to interpreting the provisions of the Act. Now, we can take inspiration from the UK Arbitration Act. As you can see on the slide, they have provided the guiding principles on which the provisions of the Arbitration Act shall be interpreted. For example, as you can see, the first one being the object of arbitration is to obtain the fair resolution of disputes by an impartial tribunal without unnecessary delay or expenses. So this, if we incorporate such general principles at the outset of the Arbitration Act 2001, this will assist the parties to understand the spirit of the legislation. Now, just to conclude, ladies and gentlemen, the primary reason behind the failed state of the arbitration regime in Bangladesh is the indifference of the legislature in recognizing and addressing the deficiencies in the Act through necessary amendments. Any legislation, if not amended from time to time, has the danger of becoming ineffective and stagnant. As a lawyer myself, I am required to give the best possible advice to my clients. Unless extensive amendments are brought about to the Arbitration Act 2001, I cannot ethically advise my clients at this point in time to insert an arbitration clause in their contracts. Why? Because they will suffer in the long run. According to the Doing Business Report 2020, prepared by the World Bank, we stand at 189 out of 190 countries. 189 out of 190 countries in the category of enforcement of contracts, and stands at 168 out of 190 countries in the terms of ease of doing business. There are now 3.9 million cases pending in the courts of Bangladesh. Ladies and gentlemen, the courts are struggling. The arbitration mechanism has the tremendous potential to ease that burden. So I am hopeful and optimistic that in the near future, the legislature will amend the existing Arbitration Act to create a robust legal framework for arbitrations in Bangladesh, which will not only restore the confidence of contracting parties, but will also encourage foreign investment. Thank you everyone for listening. Thank you, BIAC, for inviting me to this enlightening event. Thank you.
Thank you, Barrister Rahman, for your elaborate application of the amendment needed importance areas of amendment which is the dire need right away without any further loss of time. Thank you very much indeed for bringing it to the notice of the practicing lawyers as well as the policy maker of this law, and we have the right person here, the Minister for Law, Justice and Parliamentary Affairs, who will take it up and he will listen for himself, and not that he doesn't know, he does know all these shortcomings, and he will take care, he will take care to make it effective immediately. At this point of time, without any further loss of time, I would like to request Dr. M. Mahbubur Rahman. Mahbubur Rahman is the founder, chairman, and CEO of Policy Exchange of Bangladesh, a private independent policy and strategy advisory platform. He was senior economist and program manager in the investment climate and the private sector development unit of the World Bank Group, where he served for 10 years. He led several financial sectors, developed a program of aid Bangladesh with focus on investment climate, SME finance, privatization and tax reform. He is a PhD in development economics from the University of Manchester and in finance and economics from the University of Orleans, MBA in finance and economics from the University of Orleans. Mahbubur, the floor is yours. Again, I will request for the time.
Thank you, respected Chair, Mr. Mahbubur Rahman. Today's chief guest, please.
Thank you, respected Chair, Mr. Mahbubur Rahman, Chair of BIAC. Today's chief guest, Honorable Minister of Law, Vice Chair and CEO of BIAC, distinguished panelists, ladies and gentlemen, Assalamu alaikum, good afternoon. It gives me indeed a great pleasure to join BIAC on its 11th anniversary. And perhaps I joined the founder chairman, Mr. Mahbubur Rahman, in as much joy and glory and pride as I had the opportunity to join BIAC's launching. I think it was April 12th in 2011. And very few institutions in Bangladesh have been able to sort of come this long, having been sort of strengthened institutionally and creating a strong footprint in a critical area of not only law and justice, but also trade and investment and economics. This is a testament of BIAC's leaderships, particularly the chairman and also CEO Mr. Rumi Ali, with whom I had the opportunity to support BIAC in its development process, and of course the whole BIAC team. The testament of their vision, hard work, organizational capability, and also professional and social networking, very rich networking and strengthening or positioning of BIAC as a center of excellence for dispute resolution, without which BIAC would not have been able to come this far. So congratulations to Mr. Mahbubur Rahman, Mr. Rumi Ali, the current CEO, and the entire BIAC team. So we are constrained by time, and I think our keynote presenter have presented a comprehensive keynote on the issue of dispute resolution and the relevance of Arbitration Act reform. I see very enlightened the luminaries of the legal fraternity in the room, so I would not dare to step into the technicalities of Arbitration Act or the dispute resolution. But let me pick up something that Barrister Imam mentioned in the last few minutes, the policy perspective. And let me bring in the economic perspective in the form of that policy angle, which lends so much of importance for immediate action on Arbitration Act, but also the overall enabling environment of dispute resolution or contract enforcement in this country. Barrister Imam rightly mentioned 189 out of 89 countries, or perhaps 190, doesn't make much of a difference. It clearly tells us where we stand in terms of the global comparison. But let me add to that some granular numbers, which you may find more interesting or as interesting as what Barrister Imam mentioned in terms of the overall number. What does it mean for individual parties, businesses, when it gets stuck? in terms of the doing business, the time it requires in Bangladesh to resolve a commercial dispute, 1,442 days, compare that with the countries with whom we are competing for trade and investment. South Asia average is 1,100 days, Vietnam is 400 days, Indonesia is 390 days. So 1/5 or 1/4 precisely our competitors. There is a cost element, the percentage of the claim amount that gets spent into this dispute resolution process. Bangladesh is a whopping 66%, 2/3 of the total claim value. South Asia average is 29%. Vietnam is 29%. East Asia average is little over 40%. Now that tells us that not only in terms of where we stand as a country, which actually is a matter of how we are seen and how our reputation goes to the investors and international trading community. In addition to that, when it comes to the specific transactions, in terms of dispute resolution, we are at least 1/5 more expensive, or perhaps 1/4 more time consuming compared to our competitor countries. And that brings us, or that brings me to the key point that I wanted to highlight in terms of why it's so important to reform the Arbitration Act. I think a very right title, the dire need. I think FDI, private investment, it could not have been more important for Bangladesh, standing where we are today. Few reasons. One, I think Bangladesh rightly aspires to become upper middle income, high income country in the next 10, 20 years. Even if we do it in the next 30 years, that would be an achievement. But to do that, we would need to enhance our private investment from current 23% of GDP, and by the way, it's been stuck for some time around that, to 36% private investment GDP. That's a 70 percentage point increase, not a matter of joke. FDI, we have been stuck below. If we take average, the last year is less than 1% of GDP, but average is 0.5% for the last 5 years. The Vietnam average is 4.3%, Thailand 4.2%, even India next door is 2.4%. So if that's one sort of clear motivation as to why we really need to bring in the FDI, also the private investment, without which we don't have the jobs or the income of the prosperity that will take us to upper and higher middle income. But with that, we also need to add what's going on in the world at the moment. South Asia, global, also in Bangladesh. Let's be honest, the entire world economy is under pressure. Bangladesh economy is certainly also under pressure. And one of the key pressure we are facing is a balance of payment or macroeconomic challenge, or at the minimum anxieties that we have not experienced in the last 3 decades, at least not since 1989. What we are going to, so I was asked by a television interview just 3-4 days ago that, okay, what's the right level of reserve that will keep us very happy? I said, there is no right or magic number like that. If we cannot ensure enough supply and maintain the right demand, even a $50 billion reserve after 6 months will turn out to be insufficient. So we are going to have to ensure that Bangladesh keeps getting the foreign currency in as many ways as possible, and there is no bigger way than FDI remittances and exports. And when we want FDI, when we want more trading contracts for exports, the confidence in the country's contract enforcement system is going to be one of the top issues that the foreign investors, the trading partners, and also the local investors are going to look at. And that's where the Arbitration Act's role come in. And I joined Barrister Imam in expressing my disappointment that despite several efforts by the government, and we see at least 2 of the important players who were involved in those efforts, the Honorable Minister and also the former Senior Secretary, Mr. Shohidul Haq, at the Legislative Division, who took up initiatives, but the overall ecosystem has not yet allowed the delivery of the full reform of the Arbitration Act, neither the implementation of the Civil Procedure Code amendment that was done in 2012, which continues to remain without any rules. So we have seen that if the political will and the administrative support combined hand, together with the support of the stakeholders, difficult reforms can happen, and this certainly can happen. We have heard about India. I was part of the India overall reform program as the team leader of the World Bank team that supported the Doing Business Reform Program in India, and I have seen how the Indian political leadership and the Indian civil service, which by the way I found, particularly the civil service, a lot more complex than Bangladesh's, at least in mindset, than Bangladesh's one. At least Bangladesh is more private sector friendly. Sometimes they're not fast enough, or they don't know what the solutions are, and that's where we can help them. And I think that's where I would urge to Honorable Minister and through him to the government to extend further support to BIAC to continue, in order for BIAC to continue and enhance its role as a center of excellence for dispute resolution, because implementing reform, deciding about the reform is one thing, which of course we need, but implementing the reform is a lot more complex. You need to create the consensus, which clearly we haven't had in the last 2 decades in Bangladesh on dispute resolution. So an institution like BIAC can certainly help, and it is already doing, convening the stakeholders and creating that common interest, which should lead to that consensus that should help the government to actually bring in the implementation of reforms very easily. And once the reforms are done, enforcement of the reformed law or the system is even more important. And that's where, again, BIAC can play a very important role. It has created the rules, it has created the list of certified, I think we call it certified arbitrators or mediators, the pool, the professional pool without whom it is going to be difficult to enforce and reform Arbitration Act. So we hope through the Honorable Minister we can sort of convey this message to the government to help BIAC with both financial but also more importantly with the policy and other support. I am aware that government at the moment is processing a 50 crore endowment to FBCCI's proposed innovation center, which I was part of in terms of its design and concept. So, Ministry of Finance has already provided almost a 10 crore endowment to build, which is a public-private dialogue forum, and I think it is a matter of sort of high priority that BIAC gets that sort of financial as well as moral and technical support and the policy support from the government to make the Bangladesh's contract enforcement regime an effective one, which is critical for it to bring in the FDI, to enhance the export in order for Bangladesh to come out of the pressures that we are in, but also to become the high-income country as envisioned by Vision 2041. So thank you once again to BIAC Chair as well as the BIAC management for having me here, and it is wonderful joining this enlightening group on this very important program. All the best to BIAC. Thank you so much. Thank you, Mashur. Thank you very, very much. May I now invite Mr. Salim Arab Hussain, the Chairman, Association of Bankers, Bangladesh, and he's also Managing Director and CEO of Black Bank. Mr. Salim Hussain joined Black Bank Limited as the Managing Director and CEO on November 8, 2015. Mr. Hussain was previously the CEO and Managing Director of IDRC Finance. He worked in various roles in the two largest multinational banks in Bangladesh, and the Greenwich Bank and Standard Chartered for 24 years before moving to the IDRC Group. He was the chairman of the board of directors and 2010-2012 of the IDRC Finance, two subsidiaries, IDRC Investment and IDRC Securities, and so on. I would like to say that Salim Arab Hussain has been working very closely with the private sector for a long time, and he will be able to give you a picture on the issues that we are now talking about. Mr. Hussain, the floor is yours.
Thank you, sir. Honorable Chief Guest, Mr. Anisul Huq, MP, Ministry of Law, Justice and Parliamentary Affairs, Honorable Chairman, Mr. Mahbubur Rahman, Honorable Vice Chairman, Mr. Rumi Ali, Chief Executive Officer, Mr. Kaiser Chaudhry, ladies and gentlemen, it's a pleasure for me to be with you here today. And let me start off by saying that we can only have special regards for Mr. Rashad Imam and also Dr. Riaz, who preceded me. After what these two gentlemen presented and spoke about, there is very little that I can add, except to say that from the banking perspective, you will well understand why ADR is not very popular in the banking sector itself. I don't think I need to elaborate on that. The fact is that after 20 years, we now need reform to make this effective is pretty straightforward. That's a no-brainer. Actually, a few days ago, we had a meeting of the Association of Bankers in Bangladesh. There were about 35 odd managing directors, and I asked them about who amongst them used ADR or had experience of ADR, and if they had any recommendations. So actually, some of the issues that they discussed have already come out in Barrister Imam's presentation. The cost of the honorarium of the arbitration, that needs to be documented. I will not elaborate on that because Barrister Imam spoke about it. Completion of arbitration proceedings within a fixed time frame, the fast track mechanism, absolutely necessary. And also that, certain laws need to be amended for the smooth arbitration awards. We have used ADR in Brak Bank in 20 years only once, and it failed miserably. While it is considered a relatively secured option, in a small case with another bank actually, despite winning the arbitration process and having incurred a significant legal costs, even 5 years later we have still to get the award. Of course, that's nothing compared to maybe the 30 years that Barrister Imam referred to. So that there are significant challenges. And the question is, how do we make this work? What do we need to do to make the ADR process work? Well, the first question is, do the powers that be, do they want it to work? If they want it to work, then we have to start with reform as presented by Barrister Imam, and then of course the implementation, the rules, etc., etc. In the banking system, obviously, we are very important stakeholders and potential customers of any dispute resolution mechanism. I feel that our reliance on the legal system, which is totally broken down. We have hundreds of thousands of cases in the courts, and it's not the court's fault. They are just not staffed enough to be able to manage so many cases. We're talking about a reasonably large economy now, and I feel that since Sir is here now, we must emphasize that the number of courts, the number of officials is just not enough. We really need an exponential increase in the number of officials and a significant increase in the number of courts if the banks are to be able to do their job properly, and if the disputes which in the banking arena entirely relate to bad loans are to be resolved. I will not waste any more of your time except to say that I would like to thank BIAC for inviting me here. Kaiser Chaudhary, who is an ex-colleague of mine, a senior colleague of mine. We would very much like this to happen, these reforms and these implementation of these rules, because we will be your biggest customers if that can happen. Thank you very much, ladies and gentlemen.
Thank you very much, Mr. Hussain. Since you are the chairman of the Association of Bankers, you have a great role to play about dispute resolution as we have been discussing. But the time factors that you have mentioned about your one experience, I am mentioning it to the Honorable Law Minister, that is the crux of the whole problems. And we need to address this issue right without any further loss of time. It is not the law, it is not the system, it is also in the implementation process. If it is not there, we are going to suffer anyway. At this point of time, without further loss of time, I would like to invite Mr. Saiful Islam. Saiful Islam is the President of the Metropolitan Chamber of Commerce and Industry and a member of the board. Mr. Mohammed Saiful Islam is one of the leading businessmen, industrialists in the country and has 32 years of business experience in various fields like shipbuilding, leather goods manufacturing, dredging and hospitality, etc. Currently, Mr. Islam is the President of the Leather Goods and Footwear Manufacturers Association, Chairman and Managing Director of the BIAC Bangladesh and Footstep Bangladesh Limited, Chairperson Western Marine Shipyard, Narayan Engineer and Shipbuilding, and he is also former Chairperson of Confederation of International Footwear Association. Saiful Islam, the floor is yours.
Chief Guest, Honorable Minister for Law, Justice and Parliamentary Affairs, Chairman of BIAC, Board Member of BIAC, the panelists, distinguished guests, ladies and gentlemen, good afternoon to you all. It's an honor and privilege for me on behalf of the Metropolitan Chamber of Commerce and Chamber to be present here today. As a whole, what I see that business is totally a complex issue. And nowadays, if we consider the triple effect of the pandemic, the war, and the climate change, these headwinds, it has made the business more complicated. But despite that, we need businesses, we need contracts. The contracts, when we find that there is a breach of contract, we do not have any other alternative other than going to the court of justice with the help of the experts. But ladies and gentlemen, let me say one thing, that going into legal battle is an endless journey. It costs time, it costs money. Sometimes it is ever-ending, but we cannot give it up. It is a question of life and death. So we want to try to get relief of that, looking for the windows. What I find that BIAC is the window for our relief. Before 2011, we did not have such windows. So, Mr. Imam, as a keynote speaker, he has already said about this Arbitration Act, which needs to be reformed. First of all, from the business community, I'd like to emphasize that whether we need this arbitration clause, the ADR or not, without having that, we cannot improve our ease of doing business. This is 168 out of 190 countries we must give. The Honorable Minister is here today. I would urge up, let's look into the contract, G2G, B2B. Representing the trade body, but I can say that when we have the B2B contract, in the contract we put the arbitration clause. Unfortunately, this arbitration clause, we put the place of arbitration either in Singapore or in London, in most of the cases. The reason behind is that is being governed by English law. But Bangladesh is now graduating from LDC to MIC. We have negotiating power. From the private sector, I can say that we have started negotiating with our counterpart, saying that, I can give you the examples also. The arbitration, the place of arbitration, in line with other countries such as London, New York, Singapore, Dhaka. In many cases, we have become successful on that, put that clause. The chief-to-chief contract, the Honourable Minister is here. With due respect, I would like to say that government being an employer, whether there were any clause that arbitration should be in line with other countries, as I say, should be Dhaka too. That reflects our due respect to the Act which was passed in the Parliament in 2001. The reform and other thing, Mr. Imam, he has mentioned, without reform, without enforcement, how we can take it forward, the ADR. Yes, the moderator has rightly said, I have been given only 5 minutes. I think that I am being exhausted, but still then, let's do one thing from the private sector. Let's disseminate the services of BIAC. We are proud to be associated with BIAC. Let's take this institution, if not in international level, why shouldn't we take this BIAC into a regional and sub-regional basis? We need to disseminate this thing. We need to have partnership with BIAC so that the local contracts are being protected as a part of instrument. The arbitration clause are being put. The regional contracts are also being covered. The international contracts are being also covered within the ADR. So I wish all the success of BIAC. Thank you all. Thank you.
Thank you very much, the President, Metropolitan Chamber of Commerce, Mr. Islam. And very practical, we need to have the Centre of Arbitration being promoted as Bangladesh. And as he has rightly mentioned, that the government to government or business to business, they should emphasize on this. And the government, of course, mentioned that about $50 million arbitration should be. But unfortunately, it is not being practiced in all cases. But anyway, the Minister would like to build up on that. And at this point of time, I would like to invite Justice Abdul Salam Mamoon, former Justice of the Court of Bangladesh. Justice Mamoon, the floor is yours. He is a former Justice of the High Court Division of the Supreme Court of Bangladesh and one of the junior advocates of the Supreme Court. He is the founder and head of the Chamber of Justice Abdul Salam and Associates, leading law firm of the country, operating from Dhaka and Chittagong. In his highly decorated career, spanning about 40 years from both bar and bench, in addition to his successful private practice as a ladies lawyer. Mr. Mamoon has acted as the special public prosecutor and the assistant attorney general. Mr. Mamoon, Justice Mamoon is the floor is yours.
Mr. Session Chairman, Honorable Minister for Law, Justice and Parliamentary Affairs, distinguished guests, ladies and gentlemen. Mr. Imam has taken up all the points in his keynote to be addressed by the authority, particularly by the chief guest of today's seminar and also suggested some measures to be taken to address the problems that we are now facing in conducting arbitration. It is indeed we need a systematic rule for conducting the arbitration, and in formulating, framing the rules, we can suggest some points to be taken into consideration, namely formulating of central rule as to the time frame to be followed by the arbitrators in each step, and in my suggestion is that it should not be more than 14 years for each step in conducting the arbitration. And then time schedule, though maybe directory may be given as a rule for concluding the arbitration proceeding, so that the litigant people may reap the result in a given time. Then I would like to mention about the service mentality of the arbitrators, the lawyers engaged in arbitration proceeding, and of course the arbitrators are doing their best from the point of their view to render service for the litigant public, but it should be mentioned in the rule so that the arbitration, though it is mentioned in the Arbitration Act that the civil procedure code is not applicable in the arbitration proceeding, and the arbitrators may determine their own procedure, but in fact, in reality, we are following the civil procedure code in our activities, which we should avoid, and a central guidance should be given in the rules. Then the removal of jurisdiction of the district judge when an arbitration award is delivered by Justice Mr. Chakladar or Justice Mr. Rahman or the former Chief Justice or other justices. A district judge has virtually nothing to do with the arbitral award. So a step is to be eliminated and exclusive jurisdiction has to be given to the Honorable High Court Division. Mr. Sarkar, who has the jurisdiction in the High Court Division, is today, for reason beyond his control, could not attend in this seminar, but he is overburdened by the jurisdictions. At the same time, he will conduct the company matters, succession matters, arbitration matters, and many other matters like that. Instead of that, our considered view is that a bench should be given exclusive jurisdiction for arbitration by in the Honorable High Court Division by the Honorable Chief Justice, so that the arbitration matter, he can deal with the arbitration matter exclusively. And then my humble opinion is that we are dealing with arbitration, commercial arbitration and litigation, arbitration arising out of litigation. But the vast majority of the cases are coming from rural areas. And in rural areas, we do not have sufficiently equipped mechanism to bring them in the arbitration process. We should think about it, how to bring them in the arbitration process apart from village court or in the Paurushabha litigation litigation mechanism, and if we can bring them within the arbitration proceedings or arbitration framework, then a vast majority of cases come down within the mechanism, and we can bring them to a system. With this, I conclude my short suggestion, and thank you.
Thank you, Mr. Mahmood, and for your practical suggestions. And at this point of time, is the QC is online?
Yes.
Is now that QC is in London, is Mr. Mahbubur Rahman, QC, barrister at law and senior advocate, Supreme Court of Bangladesh, and senior partner, A. Hussain and Associates. Mr. Mahbubur Rahman, QC, is the first and the only Queen's Counsel in England of Bangladeshi origin, who is also a senior advocate of the Supreme Court of Bangladesh. Mr. Hussain, QC, was enrolled at the Bar of England and Wales back in 1978. Mr. Mahbubur Rahman is the senior partner of Hussain and Associates and a member of the Selborne Chambers, England. He is a registered foreign lawyer, Singapore, and fellow of the Chartered Institute of Arbitrators, UK. He has a number of other assignments and experience. We would now like to invite Mr. Mahbubur Rahman, QC from London. The floor is yours.
I've been having this morning having a little bit of problem with the internet. If someone could give me an indication that yes, I'm audible, then I'll continue.
You are audible, and many of the points that you may raise that has been discussed, we would like to go for lunch quickly.
Certainly, my lunch will be virtual. But nevertheless, thank you very much for inviting me.
We will keep your lunch reserved when you are in Dhaka.
Thank you very much, Mr. Chairman. Honorable Minister, Chairman of BIAC, my dear friend Rumi Ali, the Director of BIAC, and Kaisar Choudhury, the CEO, distinguished speakers, ladies and gentlemen, Assalamu alaikum, greetings from London on a nice sunny morning. The Arbitration Act of Bangladesh has been in place for over 20 years. And during these 20 years, it's been tried and tested in many areas. And I, as practitioner in Bangladesh and in other jurisdictions, have come across a number of points which seem to be, which seem to need some changes. And the topic of today's discussion, the dire need for reform of the Arbitration Act, is a timely one. And I think there are a number of points that can be taken into account by the Honourable Minister when he considers the issues which are raised today, by not only by the keynote speaker, but also by our colleagues who have been speaking this afternoon. The first point that I would like to raise relates to the jurisdiction of the Bangladeshi courts. And we know that in Section 3 of the Act, the Act says it shall apply where the place of arbitration is in Bangladesh. This has caused problems and serious confusion, particularly when applications are made for interim relief under Section 7 Core of the Arbitration Act. And similar problems were faced in Singapore at one time and also in India, which resulted in those jurisdictions making it specific that the jurisdiction shall apply, the Arbitration Act shall apply not only for arbitration seated in Bangladesh, but also arbitration which is seated abroad. So that is something that we need to deal with. There have been conflicting decisions of the courts. There have been conflicting decisions of the court, and in some decisions, the courts have decided that Section 7 core relief cannot be given in a situation where the arbitration is held outside Bangladesh. And then recently there's been a case decided by Justice Shortcut where he says it can be. So there are conflicting decisions. There have been previous decisions of the appellate division where again confusion reigns. So this is something that is urgently in need of rectification, and I would recommend that the Act should apply to all arbitrations, not just those to be seated in Bangladesh, but those which are held outside Bangladesh. The second point that I would like to make is also in relation to the court. Under the Arbitration Act, we can see that there are these three different courts which can have jurisdiction. In respect of appointment of arbitrators, you will note under Section 12 that the district judge who is given authority to deal with appointments in domestic arbitration is the district judge in whose jurisdiction the arbitration agreement was concluded. So that is something, that is one court. Then for enforcement of domestic award, you have the district judge in Dhaka who has jurisdiction. And then in respect of enforcement of international commercial arbitrations or for appointment of arbitrators, you have the High Court judge. So there are three different levels where you see the court can get engaged. My respectful suggestion is that there should only be one court, and it should be at a higher level, and it should be the High Court Division. The only court which will have jurisdiction relating to arbitration should be the High Court Division. We want to cut out the district court entirely because effectively the arbitrators have been dealt with the merits, they've dealt with the contract and everything, and therefore only that what is required is for a little bit of oversight to make sure that they have actually followed the law in making their decisions. It's not an appeal, but it is effectively to see whether that can be set aside for set reasons which are set out in the Arbitration Act. So that is something that I would invite the Honourable Minister and those in Parliament to bear in mind. The next point that I want to make relates to fees in international arbitration. This is a topic which has recently been looked at by the Indian Supreme Court. And what has been happening is that in many arbitrations, whether institutional or ad hoc, the arbitrators take the assignment, and having taken the assignment, halfway down the line, they say, well, you have to pay us more fees. And the parties are then stuck. And I have come across one or two cases in institutional arbitrations where the arbitrators have asked for fees beyond what is set out in the institute's rules. The other situation is that in ad hoc arbitrations, we find that arbitrators set the fee and then they say, okay, well, we have now done this, we've had 10 sessions, we're now going beyond 10 sessions, we need to charge more fees. So parties then get stuck, they don't know where they will end up. It's an area where I think some clarity is required, and I think statutory intervention will be necessary to deal with this. The final point that I want to make today relates to fast-track processes. There are certain processes in international arbitration which we come across, and I don't know whether my article has been published, but I was asked to write an article, and I have in fact written an article on summary procedures. These procedures, these processes are necessary to ensure that the arbitration proceeding takes place swiftly and the disputes between the parties are resolved at the earliest opportunity in the most cost-effective manner. So we should really have opportunity for the tribunals to give interim, partial, or final award, or interim partial award, interim final award, partial final award. So this should be made very clear. It is not actually clarified in our statute, and I would wholeheartedly recommend that this is something that should be looked at, because there are certain situations where there is no defense to a claim, but perhaps on the basis of an admission. Take that as an example. In that sort of scenario, there is no reason why the tribunal cannot make an interim, partial, final award. So that is something that we should look at. The other point that I have raised in this article is the question of early dismissal of defenses or even claims. If the claim does not have any leg to stand upon, or the defense does not have any leg to stand upon, then the tribunal should deal with it, say on a legal basis. For instance, a very clear-cut case is limitation issue. So that issue should be fast-tracked and dealt with. And if the limitation point is a good one, then that would be a complete bar to the proceedings continuing. There is no need to go into the merits, and I would wholeheartedly recommend that some sort of fast-track processes should be introduced into our law so that these can be effectively dealt with by tribunals sitting in Bangladesh. Now, with those few observations, Mr. Chairman, I thank you for asking me, you and your colleagues, for asking me to speak today. Thank you very much. I hope these can be useful changes that can be considered by Parliament and by the Honourable Minister as well. Thank you very much.
Thank you, Honourable. Thank you very much for joining us from the far distance place from UK. You are always counted as one of our very good well, not only good well-wisher, but also one of the very good promoter for establishing alternative dispute resolution as an institution in the country. Thank you.
My pleasure.
Thank you very much. So at this point of time, we would like to say that all our distinguished speakers have been very pertinent and to the point with what we should do now, and in order to bring about a change in the total scenario, that how we can prepare the act itself, and at the same time its implementation to be ensured. So this is very, very important from that point of view. At this point of time, I would now like to invite our chief guest, Honourable Minister Anisul Huq MP, Ministry of Law, Justice and Parliamentary Affairs, Government of the People's Republic of Bangladesh. The Anisul Huq do not require any formal introduction, but nevertheless, for the sake of the formality, the Honourable Minister is there since 1914. He had his honours and master's degree in English literature and Bachelor of Law from the University of Dhaka. He had his Masters of Law from King's College, University of London. Mr. Huq practiced as senior advocate in the Supreme Court of Bangladesh. He was Chief Special Prosecutor of both Bangabandhu murder case and the killing case. Mr. Huq was also the Chief Counsel and the Special Prosecutor for the Anti-Corruption Commission, Bangladesh. The Minister Anisul Huq, the floor is yours.
Thank you very much. Bismillahirrahmanirrahim. Honorable Chair of BIAC's 11th Anniversary Seminar, Mr. Mahbubur Rahman, Chairman of BIAC, distinguished discussants, eminent lawyers, dignitaries, ladies and gentlemen. Assalamu alaikum and a very good afternoon. At the outset, I pay my profound respect to the greatest Bengalis of all times, the architect of Sonar Bangla, the father of the nation, Mahbubur Rahman. With deep respect, I remember all his family members who were murdered on the fateful night of 15th August 1975. I also remember with deep respect all the martyrs and freedom fighters who sacrificed their lives in our war of liberation, and the 200,000 women who were brutally persecuted. I also pay my profound respect to our four national leaders who were brutally killed in Dhaka Central Jail on the 3rd of November 1975. I pray for their eternal peace. I feel honored to be here with you all at this seminar with the theme Arbitration Act 2001, dire need for immediate reform, commemorating the 11th anniversary celebration of Bangladesh International Arbitration Centre, BIAC, which is the only alternative dispute resolution institution in the country. BIAC has already achieved remarkable progress in facilitating arbitration and mediation in respect of commercial and business disputes between affected parties. Therefore, I congratulate BIAC for their continuous efforts in promoting institutionalized ADR in Bangladesh and the extent of their achievements throughout the years in operation. I wish BIAC a very happy 11th birthday. You can Ladies and gentlemen, the courts of Bangladesh are already struggling with the burden of a massive backlog of cases. Many countries, when faced with such a situation, opted to design innovative solutions and achieved remarkable results. Businesses have a preference for a quick and straightforward approach to settlement of their commercial disputes. But this may not be feasible through the prevailing judicial procedures. Modern businesses do not want to wait long for resolution of disputes, and as a result, the use of alternative dispute resolution methods have become widespread in developed and many developing countries. Hence, the efficiency of ADR regime is essential not only for the progress of the legal and regulatory sectors in any country, but is also vital for the economic growth of the country as a whole. ADR can play a significant role in enhancing the economic growth, which is most pertinent in our current national economic scenario, where our core areas of focus include the diversification of the resources of revenue available for national development through increased private sector-led domestic and foreign investments. ADR, as a method of dispute resolution, has been in place in Bangladesh for quite a long time, though on a limited scale. The Arbitration Act 2001 brought Bangladesh on the threshold of modern arbitration. For our businessmen and entrepreneurs who are competing in this globalized world, it is imperative that they incorporate local best practices and seek to put into practice these methods and processes. The present government, under the dynamic leadership of our Honorable Prime Minister, Sheikh Hasina, is also relentlessly working to incorporate ADR in different existing laws in order to make dispute resolution system easier and less time-consuming. We will surely make changes in the Arbitration Act 2001 if it is necessary to create a more effective, business-friendly and solution-oriented ADR atmosphere. As the government fully agrees and appreciates the need for the ADR, everybody can be assured of our fullest cooperation in the present and for the future. It needs to be understood that the legislature, being the representative of the people, needs to be brought into the frame by such seminars and discussions so that it can initiate change in the law. I can assure all that this seminar will surely contribute to drawing the legislature's attention. Honorable participants, I congratulate Mr. Mahbubur Rahman, Chairman BIAC, and the President ICCB, who is also presiding over this session, for giving me the opportunity to address this august gathering. I would like to thank the BIAC team for their hard work in popularizing ADR, for that matter, arbitration and mediation in Bangladesh. It is also a matter of great appreciation that BIAC has already been recognized by a number of international ADR institutions, including the Permanent Court of Arbitration in The Hague, the SAR Arbitration Council. I have very high hopes reposed in BIAC and its commitment to promote adherence to cost-effective ADR, which will definitely help dispose pending bulk of civil cases throughout the country. BIAC joining the process of settling commercial disputes beyond the court has created a real hope. BIAC's activities in the last 11 years, including handling non-performing loan cases, facilitating arbitration and mediation, conducting training and workshops, have substantially contributed in the field of promoting ADR practices. I must commend BIAC's continuous efforts to set up a framework on ADR. Through the various trainings and outreach activities, in addition to facilitating resolution of cases, BIAC has successfully highlighted as to how ADR can be made effective from this investment perspective as a part of the justice delivery system. In meeting the sustainable development goals, in creating an environment conducive to business, and how the new generation of lawyers, bankers, entrepreneurs, and many other professionals can benefit from adopting ADR skills at work and otherwise. What is practiced globally as part of the international best practice should also be adopted by the people of this country should we have the commitment to excel further as a nation. In the context of today's seminar, I do appreciate BIAC's selection of the famed Arbitration Act 2001, dire need for reform, which I feel is quite relevant under the prevailing circumstances. Undoubtedly, it has been a very humbling experience. I have listened with keen interest to the well-researched keynote presentation of Barrister Rishad Imam and subsequent enlightening deliberations made by eminent discussants. The findings do justify, in my opinion, the necessity to look into the suggestions regarding reforming of the Arbitration Act 2001. I wish to assure the audience that the recommendations of this seminar shall be taken up in earnest to bring about a desired fruitful change in the near future and see through a successful implementation. I appreciate BIAC for working on alternative dispute resolution, and I hope that BIAC, as the country's only ADR provider institution, continues to achieve success in all its upcoming programs. Thank you. Joy Bangla. Joy Bangla.
Many thanks, Honorable Minister. You have been supportive to our initiative from the day one, and we will continue to work with you in order to take the ADR Act in Bangladesh and take its root in the whole process of settling dispute outside the court. Thank you very, very much indeed, and we need your support for all times and in order to travel in the process of alternative dispute resolution. Thank you very much indeed.
I now request our Honorable Chairman, Mr. Mahbubur Rahman, to deliver the closing remarks.
Thank you, Honorable. It gives me immense pleasure to address you this afternoon and welcome you most cordially on this auspicious occasion of our 11th anniversary celebration. And the Honorable Minister for Law and Justice and Parliamentary Affairs, Mr. Anisul Huq, as I have said, has been very supportive to our institution from the day one. And we have, unfortunately, you have all heard that the Honorable Justice Mahbubur Rahman could not be present here due to his father-in-law expired today. Former Justice of the High Court Division, Supreme Court of Bangladesh, Mr. Mahbubur Rahman, QC Barrister at Law, Mr. Saiful Islam, President, Metropolitan Chamber of Commerce and Industry, and Chairman of Bankers of Bangladesh Limited, and Chief Executive of the Black Bank, Mr. Salim Arif Hussain, Master Riyaz, Chairman and CEO Policy Exchange of Bangladesh, Reshad Imam, Barrister at Law, Advocate Supreme Court of Bangladesh, and Honorable Justices, Secretaries, Dignitaries, ladies and gentlemen, Assalamu alaikum wa rahmatullahi wa barakatuh. In observance of the BIAC's 11th Founding Anniversary, today's seminar with the theme Arbitration Act 2001, dire need for immediate reform, has been quite pertinent to the prevailing scenario, and we have just been enlightened by the insight of related stakeholders. As we all know, in Bangladesh, the domestic and international commercial arbitration are being governed by the Arbitration Act 2001, which provides the procedural law for arbitration in Bangladesh. The main objective of ADR is to provide a cost-effective and speedy mechanism for dispute resolution. However, it has been observed that the institutional arbitration provides specific rules and directives to ensure a cost-effective and speedy dispute resolution mechanism for parties to a dispute compared to an ad hoc arbitration. In my opinion, the outcome of the seminar will contribute towards the establishment of a robust legal framework for arbitration through amendments of the existing legislation. Instead of going further and giving you an impression about the total necessity required for this purpose, I would like to say once again that your support and participation is crucial in order to bring about a change in the existing situation in the country. Therefore, and I would like to blame that our former senior secretary in the legislative division is not to amend the law before his retirement. So, nevertheless, in a lighter note, as you understand, but nevertheless, he has been working with us very closely in our formation and as well as in our promotion of the case. But nevertheless, we look forward that the minister, not that he new knowledge of some shortcomings in the law, he knows it very well, but it takes time, as you know, in the system. It doesn't work as you really wish. So from that point of view, I would consider that he has taken a fresh note in order to bring about a change in this case. And we look forward to your suggestions and recommendations in the days to come, and also to pursue the legal framework in the Ministry of Law and Justice for Country Affairs. Thank you very much indeed. As you already know that we are already having the lot of cooperation agreement with a number of arbitral institutions throughout the world, and in total more than 30 such institutions we have already signed the memorandum of understanding and cooperation agreements, including, as you have heard, with the Permanent Court of Arbitration in the Netherlands. So thank you very much indeed for your joining and for a dry subject. But nevertheless, it is what's called comes to a fruition. We would definitely think that it is going to contribute immensely in the overall process of the dispute resolution in the country, including the foreign investment which we are trying to promote, because they always try to see wherever they invest, there will be legal provisions of such case in the case of dispute resolution. Very, very important from that point of view. And I would like to thank my colleagues in the Metropolitan Chamber of Commerce, Dhaka Chamber of Commerce, for joining ICC Bangladesh for setting up, establishing this institution. As you know, this is not for profit organizations, and they have contributed from their own coffer, and we are looking forward the support of our Honorable Minister in this case, and there is no doubt of his encouragement and support. Unfortunately, that it takes time but for us to continue for a much longer time, it is very difficult. So we look forward that his support comes to a fruition in not too distant future. Thank you very much indeed. And I would now like to ask our colleague, friend, and the former CEO and currently the Vice Chairman of BIAC to say a few words as a note of thanks. Rumiali. You know who is Rumiali? Oh, you don't know? But nevertheless, Rumiali is known in the business, in the banking, and almost everywhere in the society. And we are so much favored by him during his incumbency as the chief executive, and also as the deputy governor in the central bank. He has also some contribution to the private sector, and I look forward that his support and cooperation to the BIAC continues in different capacity. Now as Vice Chairman, Rumiali, the floor is yours.
Thank you, sir. The chairman of today's proceedings, Mr. Mahbubur Rahman, chairman of BIAC. Honorable Minister for Law and Parliamentary Affairs, Mr. Anisul Huq. My colleague, Mr. Kaiser Chaudhary. I can see in front of me a sea of very important people. If I start naming them, I think you'll get bored. So, but without naming these eminent personalities in front of them, I'd like to start. And I'd like to start with a phone call which I received while coming to the venue. Last time I spoke to you as a CEO, I had said that next year I'm going to sit in front of you and enjoy the show. But that was not to be. Mr. Mahbubur Rahman always finds a way to make me work a little harder for the lunch he's going to offer me later. So that's what has happened. Now he has asked me to give a speech, totally unprepared, because I thought after the chief guest has spoken, I'm not supposed to speak. So anyway, I have got to he tries his best to keep his promise. And in fact, last year, I think it was last year, he ensured that something happens. And we attended a meeting at the Ministry of Law, where the Additional Secretary of Finance was there, and they committed, they agreed in principle that there is a need to support BIAC. They wrote in the minutes that BIAC is an important institution. It is making a contribution to the country, and it is from the private sector. I'm happy you said that, because this is where we are different, and I'll say a bit about that before I finish very quickly. And they recommended that we should be supported financially. That is the truth. In every country of the world, which this part of the world, of course, I have visited and where I have met the officials of the arbitration centers, they are either financed by the government, supported by the government, or are the government. So this is an exception. Bangladesh is an exception in this part of the world, where this is entirely done by the private sector. And I must thank, as the next CEO of BIAC, the gentleman over here, Mr. Saiful Islam, who is representing the Metropolitan Chamber, the Dhaka Chamber of Commerce, and of course our chairman, ICC Bangladesh, who have supported us so much in setting it up and supporting us always. I hope their support will continue, but the critical support we need now is continuation of the process Honorable Minister had started. And I will request him once more, using this opportunity of having him here, that he continues to support us and puts this to its fruition. And we are supported, because the sustainability of this institution entirely depends on this. With these words, I'd like to thank you all for coming and listening to this very important session. And I'd like to thank Mr. Rishad Dewan. I heard him completely and with a lot of attention, and also others who spoke. But I usually don't comment on these subjects because I'm not a lawyer. And I don't want to expose myself in front of so many dignitaries of law. Thank you very much, everyone.
Thank you, sir, for your valuable address. Ladies and gentlemen, we have small tokens of appreciation. 7th anniversary memento to our chief guest, Honorable Mr. Anisul Huq MP, Minister for Law, Justice and Parliamentary Affairs, Government of Bangladesh. I humbly request the Honorable Chief Guest and our Chairman to kindly present mementos to our distinguished speakers. I now call upon the speakers to receive their mementos. Firstly, Justice Abdul Salam Mahmood. Barrister Mahbub Kabir on behalf of Mr. Akmalul Hussain QC.
Send it to London.
Mr. Saiful Islam. Mr. Selim R.F. Hussain. Dr. M. Mahshur Riyad. Mr. Rishad Imam. I now request our Honorable Chief Guest and Chairman on the session to remain on the stage, and I further request BIAC board members, CEO of BIAC and speakers at today's seminar to come on the stage for a formal photo session. Ladies and gentlemen, it has been a privilege to have you all with us for making our 11th anniversary seminar a success. Heartfelt thanks to all present here for your support and cooperation throughout. This marks the end of today's event, and we invite you to lunch at the Meghna, the room opposite to this room. BIAC team will assist you. Thank you once again.
Global